I'll be going over the beginning of Chapter 4, which covers intellectual property. We'll start with 4.1, which is principles, laws, and cases. This is the nice little quote that was at the top of the chapter. It comes from the U.S. Constitution and basically conveys the essential intellectual rights that creators have. What is intellectual property? The book starts by defining what a copyright is. Copyright is a legal concept that defines rights to certain kinds of intellectual property and protects creative works. Facts, ideas, and concepts are not copyrightable. Those deal more with patents, but the book focuses on copyrights. So the first copyright law was passed in 1790, and it covered books, maps, and charts. So for example, what would be the intellectual property of a book? It wouldn't be the book, the physical book itself, which the owner would have the right to give away, lend, or resell. It would be more the plot, organization of ideas, or the work that the author put in to create the book. The author is also the only one with the legal right to make copies of it. So with all these new technologies arising, it's harder for these copyright laws to be enforced. With a lot of works being stored digitally now, it's easier to make perfect copies of intellectual property. The internet makes it a lot easier to find products that you're trying to get for free. And peer-to-peer technology makes it easier for people to download and share files. Equipment and software, the book gave the example of more discrete cameras that maybe people bring into a movie theater, record, and upload it for people to watch. Editing software, you can slightly alter a video or sound to bypass certain laws. Ethical dilemmas, we will start with this short video.
Hey, come look at the site.
Oh, cool. Can you download the Foo Fighters?
Yeah. Hold on. What did I do? You know it's illegal. Download copyrighted music. I'm taking you in.
Pay for music, never legally download.
So yeah, that was a nice video that kind of conveys a message of the consequences of illegally downloading copyrighted material. And it's pretty funny. There's arguments for both sides of this dilemma. The book gave some examples of people that kind of stand for the right to be able to pirate things. Some of their arguments are that it doesn't decrease the use and enjoyment that other people that have their own copies get from it. They claim that whoever created something isn't losing out on sales because they weren't going to buy it, even if they couldn't find it for free, they weren't going to buy it anyways. The company is a large, wealthy corporation. They don't need my money. Making a copy for a friend is just an act of generosity. Everyone does it. You would be foolish not to. Or they wanted to use something but had no idea how to get permission to use it, so they just went ahead and did it. And then arguments against copying. Say that creator was asking for a price. They probably rely on this income to continue doing their work or simply to live. Taking a creation for free diminishes the value of the work. You wouldn't download a car. So the content industries claim that about 1/4 of internet traffic worldwide consists of copyright infringing material. So there's a lot out there. And we're faced with this dilemma a lot because it's so easily accessible. I think a good example is college textbooks. They charge like a couple $100 to buy a book that you probably just use for the semester, and it'll be outdated in a year. You can't really resell it for much. But you might be able to just Google the name of the textbook and then find it for free and not have to pay all that money to get it. So there's a lot of tough decisions that you have to make and decide on what your morals are about that kind of stuff. Significant legal cases. We'll just go over what the Napster case was. Napster is a web service allowing users to copy songs from the hard disks of other users. This was a company that was big in the late 90s. I think they started in 1999. And then within a year, they had more than 50 million users and over 100 million MP3 files. So a bunch of record companies got pissed at them and tried to sue them for copyright infringement. Some of the issues that had to be determined were was their service under the fair use guidelines, and if it wasn't, then should Napster have to be responsible for the actions of their users? So Napster argued that since the people were making personal copies and not commercial, it falls under the Fair Use Act. The copyright experts rebutted by saying personal meant very limited, like within a household, and not trading with thousands of strangers. Then they go on to claim that they didn't hurt the record sales and users would sample the music and then buy CDs that they liked, which the music industry claimed that Napster severely hurt their sales, and they presented some data that did show that the sales were going down, but there's no really way to link it to just solely to Napster for it. They also claim that they were not responsible for their users' actions. They didn't keep copies of the songs on their computers. They just provided the service for users to connect and download songs from each other. The final ruling was that the court ruled that Napster knowingly encourages and assists in infringement copyrights. So they were shut down in 2001 until another company bought them and turned it into a streaming service. Responses to it. So since there's so much of this stuff out there, they're trying to figure out a way to stop people from doing it. So there's numerous approaches to prevent it listed there. Digital rights management is another big thing. Digital rights management is a collection of techniques that control access to and uses of intellectual property in digital formats. It can prevent saving, printing, making copies, distributing, or fast-forwarding commercials. So it's a different way of offering a product to avoid redistribution. It's not really something to catch copyright infringement. It's more of a way to try to avoid it from the start. It receives a lot of criticism. It prevents infringing uses, but it also prevents fair uses. For example, it could prevent use of small excerpts from it for review, or if somebody wanted to create a new work with it. And then the paper our group reviewed in class argued how DRM restricts a user's freedom with a product so much that is not always profitable or ethical in itself.